For decades, we have allowed the Supreme Court of the United States, as well as the general consensus of the population, to destroy our Constitution. Specifically, I have in mind today to talk about the 14th Amendment and birthright citizenship. Millions upon millions of people are here, having been born on the soil of the United States, to parents who have been come in here or brought in here illegally. And that birthright citizenship actually has really destroyed not only the culture of America, but also the Constitution. So one of the things that President-elect Donald Trump says that he wants to be sure to tackle is the issue of whether children born to illegal immigrants or other foreigners here in the United States should be automatically granted citizenship, and whether that will go to the Supreme Court and whether or not he can do anything about it. He plans, he says, to pass some executive orders or write some executive orders dramatically altering the way that birthright citizenship has been granted. So at issue is the 14th Amendment. So let's look at the 14th Amendment very quickly. This is from Article 14, or 14th Amendment, and then Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Now that's the wording of the 14th Amendment. So the 14th Amendment has been twisted, it has been taken out of its context, and has been applied for the last several decades, as long as I can remember, to people who come here illegally, have children here, and then those children are counted as citizens of the United States. Then they become, of course, in turn anchor babies, and then the rest of the family comes. So then we have now in the United States of America, perhaps up to 10% of the population never having been born in the United States at all. Donald Trump tells us he's going to tackle this issue when he comes into office, and hope that he does. He has recently set out 2 tweets regarding this particular issue. So number one is on October 31st. He made this comment: so-called birthright citizenship, which cost our country billions of dollars, is very unfair to our citizens and will be ended one way or another. That, of course, is exactly right. It's unfair to citizens. It's unfair to people who live lawfully in this country. And it has cost us billions upon billions of dollars. And it's one of the reasons that most working people now have to work 2 or 3 jobs. Matter of fact, a household of 2 people, husband and a wife, have to work maybe 3 jobs, sometimes 4, simply to make ends meet, because the taxation upon us is so heavy at this particular point, and part of that taxation goes to paying for this birthright citizenship and illegal aliens. Here's the second tweet that Donald Trump put out. He said, it is not covered, that is, birthright citizenship, is not covered by the 14th Amendment because of the words subject to the jurisdiction thereof. Many legal scholars agree. Harry Reid, for example, was right in 1993 before he and the Democrats went insane and started with the open borders, which brings, of course, massive crime. Don't forget the nasty term anchor babies. I will keep our country safe. This case will be settled by the United States Supreme Court, and that's what Donald Trump tweeted. So let's think about this. He's covered a lot of issues right here in these 2 tweets, a lot of ground, but he is exactly correct on the issue. Now, the Congressional Research Service has weighed in on the issue as well. They tell us that the courts apparently have never ruled on the specific issues of whether the native-born child of an unauthorized alien, as opposed to the child of lawfully present aliens, may be a U.S. citizen, or whether the native-born child of a non-immigrant alien, as opposed to legal resident aliens, may be a U.S. citizen. So basically, they've never really weighed in from the Congressional Research Service on the issue as to whether or not a person illegally residing in the United States, having broken our laws to come here, and now their children, are they now United States citizens? So what are the possible solutions here? Well, one of them is simply to go back to original intent, and we'll talk about that in just a moment. But someone has also suggested this. Here's another possible solution. And it could come from the Senate and the Congress, either in the form of a statutory amendment, which would further define language in the 14th Amendment to rule out birthright citizenship to non-residents, or a constitutional amendment which would require the ratification from 3/4 of the states in addition to 2/3 of Congress and the Senate. Now, I think those solutions are far-fetched. I don't believe that we'll be possibly getting those solutions in place. Just for example, look at what's taking place in our country right now regarding illegal aliens. The law tells us very plainly that people who are non-citizens of this country coming in must come in at a port of entry. If they're not, they must be detained and taken out of this country. That's the law. But the Democrats are showing their absolute lawless character and colors by having all these sanctuary states, sanctuary cities. Look at Chicago, look at San Diego, look at the state of California, how they are saying we're not going to cooperate. That shows you the color of the Democrats. They're anti-law, they're lawless. So I don't think that the leaders of the lawless Democrats are going to go along with an amendment that will cut out anchor baby possibilities from the 14th Amendment. But let's go back to the 14th Amendment history for just a moment. Let's just educate ourselves on what the 14th Amendment was really about, why it was given, and note carefully the original intent. And we'll talk about why original intent is so important in just a moment. The 14th Amendment states, once again reiterating, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Now, the sticking point here is subject to the jurisdiction thereof. That portion of the 14th Amendment, first interpreted by the Supreme Court in 1873 in what were called the slaughterhouse cases, relating to citizenship of African Americans or former slaves. The majority opinion in 1873 in those cases said this. Now listen to this. The phrase, subject to its jurisdiction, was intended to exclude from its operation children of ministers, that is, foreign ministers who come over here, consuls, that is, individuals who are representing another government coming here. It absolutely eliminated those from consideration, or citizens or subjects of foreign states born within the United States. In other words, people who come here illegally, it would cut out children born to those individuals. That's how the slaughterhouse cases went in 1873. Here's a great constitutional scholar and director of the Chapman University Center for Constitutional Jurisprudence. His name is John Eastman. He said, if indeed, he's talking about the 14th Amendment birthright citizenship issue. He said, if the founders are the ones who rather crafted that amendment, intended that illegal aliens can come on U.S. soil, have a baby, and then that child becomes a U.S. citizen, he says, you're sadly mistaken. If that were the case, he said, the Indian Citizenship Act of 1924, which gave, of course, United States citizenship to American Indians, 1924, would not have been necessary if Congress believed that the citizenship clause itself confers citizenship merely on the accident of birth. That's exactly right. The very reason that we have in 1924 the Indians Citizenship Act granting citizenship to American Indians is because we did not recognize the idea that is now floated so popularly that people who come here illegally are people who are not citizens of the United States having children, that those children automatically, because they're born on U.S. soil, automatically become United States citizens. Now, other people argue today this way. Well, the children of illegal aliens become U.S. citizens upon birth because of the specific wording of the 14th Amendment. The specific wording, of course, is the very fact that we just read in the 14th Amendment. The wording is this way: all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. So we're told by those on the other side saying, well, the wording of the amendment is that children of illegal aliens become U.S. citizens because of that wording of the 14th Amendment, the specific wording. Now, what is the answer to all of this? In my view, the answer to all of it is really original intent. Original intent. What is the original intent of that amendment? And we're going to see how it has been absolutely, vastly twisted out of its shape and out of its context. Thomas James Norton, in a book called The Principles, or the Constitution of the United States, its sources and its applications, actually, he tells us that after the Civil War, remember the 13th Amendment was passed, freeing the slaves, but they decided, that is, our Congress decided, that the 13th Amendment was not enough. Former slaves were forbidden to appear in towns. They were forbidden to appear in any other character than menial servants. They had no right to purchase land. They were not permitted to give testimony in courts where a white man was involved. So it was felt that something more than the 13th Amendment was necessary. Now that is the background to the 14th Amendment. Now furthermore, note this carefully. Under the constitutional period, and I would say that would be taking us from the Constitution up to the Civil War period, the citizen was considered to be a resident of his state, not in contact with the federal government at all. He owed allegiance primarily, first and foremost, to his state. And the state, at that point, dealt with the nation. Thus, this theory, that is, I'm a citizen of the state, primarily, before I'm a citizen of the United States, that theory was set aside by the 14th Amendment. Now, by the way, just taking an aside, going up a side alley here, Robert E. Lee, for example. Robert E. Lee was not in agreement with slavery. He was a citizen, however, of the state of Virginia. And he could not, in good conscience, for all of the Lees were living in Virginia, he could not in good conscience go against his own kinfolk, his own people, and his own state, the state of Virginia. So he, of course, became a general in the Southern Confederate Army. But that was not because he believed in slavery. That was not because he believed in slaves. It was because he believed that he was primarily a citizen of the state of Virginia, first and foremost. And he wrestled with this, and finally, of course, he resigned his commission from the United States Army. Now, many people today don't recognize that. They don't think anything about it. They just think, well, he was a Southerner, he was a Confederate, therefore we got to take down a statue, all that kind of nonsense. Well, the theory was, before the 14th Amendment, that a citizen was a citizen of his state. So in no case was it that people who came here illegally could give birth to children, then the children become citizens and thus anchor babies. That was absolutely out of the pale. That had nothing to do with the 14th Amendment. What has actually been taking place is the twisting and torturing of our Constitution by those who say, well, the wording of it tells us if you're born on U.S. soil, then you're citizens. That is not the intent. The original intent, if we don't have original intent, as Justice Clarence Thomas rightly says, if we don't have original intent, then the Constitution and its amendments mean nothing more to us than the latest football scores we make the Constitution say whatever we want it to say. Taking things out of context, applying them to situations to which that original context was not addressing, that is absolutely misdirecting the entire Constitution. And it is done so frequently today. Let me give you an illustration regarding the Bible. The Bible has many times been twisted. The scriptures have been twisted. And I'm going to give you an illustration where, taking out of context, Barack Obama himself destroys the context of the Bible, the passages from which he drew some of his illustrations. So when he was running for office the first time, he made comments regarding the Old Testament. He said this, and here's a direct quote: "Which passages of Scripture should guide our public policy? Should we go with Leviticus which suggests that slavery is okay and that eating shellfish is an abomination? Or should we go with Deuteronomy, which suggests stoning your child if he strays from the faith? All right, let's stop here for a moment. What has Obama done? Well, number one, he's stumming his nose at the Bible. He knows nothing about it. He has taken it blatantly out of context and therefore twisted the scriptures to say what they should not say. Now, what do I mean by that? Well, number one, Leviticus and Deuteronomy were part of the Old Testament law, and if Barack Obama had been wise enough to look at or had been interested enough to examine what the New Testament says about it, the Old Testament law was nailed to the cross. That was for the Jews in the Old Testament period. It is not a valid system today. We find that in Colossians 2, 14 through 16, Ephesians chapter 2, verses 14 through 17, and many other passages, Romans chapter 7, verses 1 through 4. That the Old Testament was nailed to the cross. It is no longer valid in the New Testament system. We are under Christ's law. So Barack Obama just took that passage out of context, applied it to something to which it should never refer. But number two, not simply that, but God was, and he didn't say that slavery was okay. God simply regulated a practice that was already current in all of the ancient world, where all of the countries were practicing slavery, but our Lord put a humanitarian concept in place regarding slavery, and that is that no one should be a slave for life. Now, persons could, in the Old Testament, sell themselves for 7 years to an indentured servitude, so to speak, to pay off debt. Or, if they would sell themselves longer than that, any person who was held in captivity would be released every 50 years. There was no permanent slavery in the Old Testament. A person could, because of indebtedness, sell himself to another person to work for that person. That is exactly what God said. It shows us that it was not permanent slavery. That kind of concept, Barack Obama did not take himself, he did not inconvenience himself enough to learn. And how about shellfish? Once again, it was the Old Testament, and because of the sanitary laws of the Old Testament, it was more dangerous than some of those meats that they not eat them. And so shellfish, once again, under the Old Testament, not a valid concept today. And how about child stoning, Barack Obama? Child stoning? No, it's not child stoning. It was a person who is old enough to act wickedly against their parents, rebel against them. Those persons were to be stoned. They were not talking about little kids who had backtalked their parents. No, Obama needs to go learn what the Bible actually means. But all of these are illustrations of people taking things out of context, and that is exactly what is done when the 14th Amendment, which was designed simply to tell us that slaves were former slaves born in the United States, were citizens not only of the state, but also of the United States, the country, and that they should be granted full rights of citizenship. When that 14th Amendment is abused to say that, well, people who come here illegally can have a child here, and then that child becomes a citizen of the United States. No, that has nothing to do with the 14th Amendment. So we need to go back to original intent. If you don't have original intent, then you don't have anything at all.